Further hearing in the appeal, Lehtimaki and others against Cooper.
Yes, Mr. Morpeth.
Lords, my lady, morning. The final point that I was going to address on jurisdiction is the effect of section 217, and necessarily as part of that I'm going to also deal with the third point that my learned friend advances that I mentioned yesterday, the point about the Chancellor having ruled on this and therefore Dr. Lehtimaki, it is said, being bound by the Chancellor's ruling and not being entitled to challenge that, and the two are intertwined, so I'll deal with them together. I dealt with some of that yesterday, which I'm not going to go over again, the surrender of discretion point, in my submission for the reasons I gave yesterday and the reasons that the Court of Appeal gave. The surrender of discretion point doesn't work. And what this argument is really reduced to is a stark point that the Chancellor has ruled on the merits of the grant, and Dr. Lehtimaki is therefore bound by that ruling and cannot challenge it. And it's as stark as that. I should make the point at the outset, and I don't do it simply as a technical point, that this is not actually an argument that is raised in my learned friend's grounds of appeal or in his written case. In both the grounds of appeal and the written case, he refers to the fact that the Chancellor ruled and says that's important that the Chancellor has ruled on the merits of the grant and that hasn't been appealed, but that is always linked with, therefore, the court in the exercise of its inherent jurisdiction over charities can direct Dr. Lehtimaki how to vote. And I've obviously dealt with that at some length, that second part. But as I understand it, the much more stark point is being put that regardless of the court's inherent jurisdiction, the fact that Dr. Lehtimaki was a party to the action and the fact that the Chancellor has ruled on the merits of the grant is itself a complete answer to this case. As I say, it's not part of the grounds of appeal or the written case. I've been fairly careful not to take technical points so far on that. I could have taken a point on my learned friend saying the order is just a scheme. That's not something that's in his grounds of appeal. But that I'm able to deal with. I've got all the authorities. This is one where I do say there is something more than just a technicality, because had that stark point been put at more than one day's notice, no doubt we would have gone away and done some research into it and tried to see if we could dig out any cases about courts trying to achieve indirectly what they can't do directly, and to see if we could find any law on that, which there may well be some. We simply haven't had the time to do any detailed research on that. I'm going to answer the point as a matter of principle, and I say as a matter of principle it is wrong for the reasons I give, but I do urge your lordships and my lady to be careful on this, because it is a point that's not been raised. It's not been dealt with in the usual careful way that one might expect when a point has come as far as this court. But my lords, my lady, with that introduction, can I answer it as a point of principle? And I do say this is an answer to the point, and one doesn't really need to trouble about it any further. And the short answer, we say, is that what the court cannot do directly, it cannot do indirectly. And this argument proceeds on the assumption that the court has no jurisdiction, either under the charitable jurisdiction or the trust jurisdiction, to tell a member how to vote. But the answer that is given is that doesn't matter, because the judge can simply express an opinion as to what the right answer is, and because the member, if the member is a party, he is bound by it. And we say that can't be right, because it is the judge doing indirectly what he can't do directly, and it would cut through all the law we've been through on trusts and charities, that instead of telling someone what to do, the judge simply expresses his view and says, well, now that I have ruled on this point, you are not entitled to disagree with me. And it completely overrides the discretion of the member or the trustee. And if I can illustrate that by looking at what the Chancellor actually did, that puts flesh on the bones of that argument, because one sees it very starkly. If I could invite you to turn up the Chancellor's reasons at tab 4 of the core bundle, MS 290. Paragraph 128 of the Chancellor's judgment, MS 290, is where the Chancellor sets out his reasons as to why he concludes that the grant is in the best interests of SIF. And he says, my main, but not only, reasons for reaching this decision can be briefly summarised as follows. And the first is in paragraph 1. He says that the April and July agreements were entered into in good faith by Sir Christopher and Miss Cooper and by the independent trustees of SIF, and it would be inappropriate to allow any of these parties to renege on such a deal unless there were strong reasons requiring the court to do so in the interests of SIF and charity. Now, that may have been a relevant factor, clearly was a relevant factor for the Chancellor, exercising the surrendered discretion of the trustees. But that cannot be a relevant factor for members when they are asking themselves whether or not they should approve the grant. Because the whole point is the trustees have entered into a self-dealing agreement. The members are being asked, should we approve that or not? And they can't say as an answer to that, a reason for it, well, the trustees have said it's all right, therefore we're going to go along with it. We don't want to renege on the trustees' deal. And the members themselves have not, as members, signed up to the April or July agreements. Dr. Lehtimaki has always been very clear that he is not willing to sign up to an agreement to support the grant, precisely because he wants to be able to give it independent thought and review. So it can't be said that he is reneging on any deal. So the first of the Chancellor's reasons may be a reason the Chancellor thought was important, and clearly was, but it can't be relevant to Dr. Lehtimaki's exercise of his discretion. The second reason... I'm sorry, my Lord. Yeah.
Can I just... I'm tempted to say why not, but can I just ask in a slightly politer way? The judge appears not to be just expressing an opinion. He's deciding a question that he thinks has been put in front of him for decision. As I read the language of 127 and 128.
Yes.
The question I think thinks he's been asked to decide is whether the grant is in the best interests of the charity.
Yes, Lord.
Regardless from whose perspective one looks at it, it's just an objective question. Is this grant in the interests of the charity? If that is the question he's asking, why is it relevant to some people and irrelevant to other people whether making or not making the grant would involve two very important players in the charity reneging on an agreement which they've made?
Well, my Lord, there are a couple of points to draw out of that. First of all, I wasn't going to argue this point, but it may be relevant that I'm not sure I would say it's not necessarily correct to say that this is a finding of fact rather than a statement of opinion, because at the end of the day it is difficult. There are shades here, as the Chancellor acknowledged in paragraph 135, which I referred you to yesterday, where he said different people could reach different views. And this is not something where there is a definitive view at the end of the day. It is something on which people...
The court frequently has to make a final decision about something about which reasonable people could reach different views.
Yes, except here, my Lord, it is specifically the Chancellor acknowledging that a reasonable fiduciary could disagree with him. As I said, that's not the thrust of what I was going to say. What I was going to say was the reason it matters that one is looking at this through different lenses, as it were, and that the Chancellor is looking at it through the trustees' lenses and Dr. Lehtimaki is looking at it as members, is that when one unpicks what happens, and I was going to come on to this in a moment, having gone through the three reasons, to say it can't make a difference to the way in which Section 217 and 201 apply, whether the Chancellor is exercising the discretion of the trustees or they're doing it themselves. But if the Chancellor is right, or if this point is right, then it does make a difference. Perhaps I could just go through the three reasons and develop the point, my Lord, because it may be clearer when I've got to the end point rather than trying to explain it halfway through, if your Lordship would bear with me for a moment. But I will come back and deal directly with that. If I can just run through the three reasons. The second reason is that the agreements involve 40 million extra being secured for charitable purpose, and that will increase the assets of BWP, Miss Cooper's charity. Now, again, that is something the Chancellor is taking account of because he's looking to the wider interests of charity. But members of SIF who are simply asking the question, is this in the best interests of SIF? 40 million going into BWP doesn't help SIF at all. And so again, it may be a relevant consideration for the Chancellor, but it's not a consideration for members.
It's part and parcel of a wider deal, isn't it? That it surely shouldn't just be looking at the extraction of funds, but at the totality of the benefits that that will unlock.
Yes, although it is part and parcel of a wider deal, but the benefits to... Perhaps I could invite the court to go back to paragraph 113 at 286. The benefit to CIF of BWP's work is minimal, and these are the submissions at 113 of Mr. Henderson at the time for CIF, saying Mr. Henderson listed a number of factors that he said could potentially weigh for or against the making of the grant, but which should, he submitted, be regarded either as equivocal or of little weight. First, BWP, that's Miss Cooper's charity, BWP's work would complement CIF's work, so the grant could be seen as a method advancing CIF's charitable purposes. The money representing the grant would, however, be available for CIF to advance these purposes directly if it were not made. So the fact that BWP is doing something and has an extra 40 million is a factor I would submit of very little significance to Dr. Lehtimaki in his considerations.
The submission which the judge is there recording is that it doesn't add much to the fulfilment of CIF's charitable purposes, that the same money is being used by BWP rather than CIF, but the judge's point too is an extra 40 million.
The point I was taking, Your Lordship, to that for was that the fact that BWP is doing some work doesn't really help CIF. They may do the same sort of things, but there is no particular benefit from CIF from BWP doing its activities. And
Are their purposes in fact the same? I haven't checked.
The purposes of CIF are very wide, although in practice it's to help children in developing countries. But in the memorandum they're extremely wide. The purposes of BWP, I'm not sure that we have that in evidence, although the grant is given for the same purposes to help children in developing countries. And that's in one of the grant agreements, Lord. Lord, the third reason that is given by the Chancellor is that the making of the grant will bring an end to incredibly hostile dispute and the governance problems that have been created for CIF. Now, again, that was an important consideration for the Chancellor. It's of limited consideration, if any, for Dr. Lehtimaki, because the governance problems, it's been confirmed by CIF, are now resolved. And one sees that if we go back in the core bundle to tab M, MS213, it's a letter attached to my learned friend Mr. Crow's skeleton. It's a letter from CIF of the 21st of June 2016, and the third paragraph is the one that he refers to in his skeleton, his written case. He says, this is Mr. Sweeney on behalf of the Governance Committee of CIF. We are confident that CIF is functioning effectively and has put behind it the governance difficulties of 2015. Now,
Mr. Morpeth, you're obviously making some important points which show that there could have been another view taken about this. But I wonder whether you are by the back door seeking to object to something against which you did not appeal, namely the best interest finding. You seem to be suggesting there can be best interests for one purpose and not best interests for another. And I find that concept quite difficult.
what I was about to develop, my lord, and perhaps to explain the practical difficulty that this causes, and the reason I was showing you the reasons that may have influenced the Chancellor and saying that the reasons that Dr. Lehtimaki may take into account may be entirely different, is because they are different exercises being done. And if it's right that the trustees can surrender their discretion, that the members can get dragged into that process and are then bound by what the judge says, what has happened is that by the surrender of the members' discretion, surrender of the trustees' discretion, the members' right under section 217 has turned from being a power to approve or veto the trustees' approval of the grant, or the trustees' decision to make the grant. It's turned from that into some right to come along and make submissions to a judge in the High Court. And then if the judge does something that the members disagree with, the member is then in the very difficult position of trying to say that is a conclusion that no reasonable judge could have reached, which, as everyone knows, is incredibly difficult. And that's the position Dr. Lehtimaki finds himself in. And what I'm trying to answer here is I'm not challenging the Chancellor's finding on the grant, my Lord. What I'm trying to answer is the point that it necessarily follows, because the members are dragged into the litigation by the trustees' surrender of their discretion, that members are bound. And that, in my submission, is the most difficult consequence of this, that what it does is it turns a power which the members have, a genuine discretion under Section 217, as to whether to say yes or no to the trustees' decision, it turns that into something completely different. They've got to come along to the High Court, try and persuade a judge who's going to exercise the discretion effectively for them, without them having surrendered it, and it's almost impossible to challenge. I mean, there is no challenge to the Chancellor's finding. Just as the Chancellor said a reasonable fiduciary might disagree with him, it's recognised that a reasonable fiduciary might agree with the Chancellor. And taking a step back, there does seem to be a perception that Dr. Lehtimaki is going to say no to the grant. Well, that is not the case, my lords, my lady. Dr. Lehtimaki wants the opportunity to consider carefully, and I'm going to take you to a bit of his evidence in a moment, to consider carefully whether or not to approve in accordance with his statutory duty. And one of the things that he wants to consider is, why 360 million? Is 360 million the right number? Because that is entirely the product of haggling between Miss Cooper, Sir Christopher, and the trustees. It started somewhere around £1 billion, someone offered something far less, and they ended up with 360 million in the middle. It's not a number that's been arrived at in the way that SIF would normally arrive at it, by asking the question, should we make a grant to this institution? What benefits is this charity going to be giving to the sort of people we're trying to benefit? What is the right number to give them? What right of review should we have over the money that's being given? Purely the result of some haggling consequential upon a divorce. And the role of members, Dr. Lehtimaki would say, the role of members is actually to step up and say, is this appropriate? Is it right for $360 million to be given to Miss Cooper's foundation as the price of getting rid of her? I referred in my skeleton to an article that Mr. Pierce, my learned friend Mr. Pierce, wrote, saying it's very unusual for the assets of a charity to be divided between the warring trustees, and that is correct. This is highly unusual.
But aren't you underscoring the submission that has been made that Dr. Lehtimaki's position is undermining the position of the court? The court is exercising a jurisdiction conferred on the Crown as parens patriae, which is to look at the overall public benefit. Therefore, it may, for instance, look at both charities together and say what is the best outcome as regards a division of assets between the two of them. It's not obliged to take that central view, have the focus which a member without fiduciary duties might have in relation to a company.
I respectfully agree entirely with that, my lady, but I say that explains why it is important that Dr. Lehtimaki, as a member, has his say for SIF, because Section 217 does not say that members should have regard to the interests of charities generally. Section 217 gives Dr. Lehtimaki and members the right to approve or not approve the transaction. And we accept they've got to do that in the interests of SIF. Everyone agrees with that. There's an issue as to whether it's a fiduciary duty or not, but everyone agrees he's got to act in SIF's interests. And that's exactly the reason why he might come to a different conclusion. The Chancellor might say, from the lofty tower of looking at it as charities generally, this is good for charities, therefore I'm going to approve it. But Parliament has said the members of SIF are entitled to say, our trustees are about to give away a chunk of our money to one of our trustees as the price of getting rid of her. This is self-dealing. We, the members of this charity, are told by Parliament that we should review whether that is acceptable or not. And that, in my submission, is a very important protection for the charity. The essence of Section 217 is that the moment trustees are engaging in self-dealing, there is a moral hazard there. There is a conflict already. It's not a risk of conflict, there is a conflict. And the members are being asked, despite that conflict, do you approve of the money being given to the benefit of the departing trustee? That's the whole point of Section 217. And in our submission, it is vital that the members be given the chance to exercise that power. And it's not, and I tried to put this to the Chancellor, he didn't agree with me, the Court of Appeal did. It's not a case of trying to challenge or second guess or undermine what the Chancellor was doing. He was doing an exercise that he'd been given by the trustees and asked to do. This is a different exercise that Parliament has given to Dr. Lehtimaki. And it's not saying the Chancellor is wrong. It's not saying the Chancellor did anything wrong in the decisions that he reached. But Dr. Lehtimaki is approaching it with different skill set. I've put it in the, I think it was in my written case, Dr. Lehtimaki is a very experienced economist. He's got 6 degrees from Harvard and Stanford. He's a very experienced businessman. He necessarily approaches this from a different point of view of a lawyer. The Chancellor comes with different skills. He looks at it with his skills and the information he's got. Dr. Lehtimaki looks at it with his skills and his information, and they are bound to be different. It's not just the skills, it is the information as well. That Dr. Lehtimaki, one of his concerns is that there has been no investigation of what BWP is actually going to do with this money. 360 million is going to be handed over to BWP in instalments over 5 years. No one has actually done an analysis, which an economist would do, of what is going to be done with this money. Is it going to be used better than SIF will use it? Is it going to be used as well as SIF will use it? Or is it going to be used worse than SIF will use it? We simply don't know. And that exercise wasn't done, principally because everyone who put evidence in front of the Chancellor had signed up to support the grant. It's no criticism of the people who put the evidence in. They no doubt acted in the best way they could, but they'd all signed up to support the grant. It's no criticism of the Chancellor. He dealt with it on the information he had in front of him. Well, my Lord, breaking that down, he was joined on day 3 of a 4-day trial.
It was late.
I made that point. It put me in considerable difficulty.
Yes.
The Chancellor said to me, well, I know you, Mr. Morpus, you can go away and read all this overnight. And flattered though I was, it wasn't realistic. And I came back the next day and made what submissions I could. I then said, could I have 2 weeks to put in some submissions and some evidence? And the Chancellor said, Mr. Morpus, you know me, I'm going to go away and start writing the judgment now. I'll give you till next Wednesday. So I had 4 working days to put in some evidence. And there was at some point in a slightly testy exchange that the Chancellor said to me, are you asking for an adjournment, Mr. Morpus, in a voice that made it perfectly clear what the consequence of the application would be, so I didn't ask for one. And we weren't, as the Chancellor records in the judgment, we weren't trying to be obstructive. The idea of getting this all adjourned because we'd been dragged in at the last minute would have made things far worse. But we did the best we could, but there was no possibility of Dr. Lehtimaki going off and instructing some consultants, getting information out of BWP, first of all, to say, what are you going to do with this money, and then having someone look at it. Simply, well, it wasn't achievable in 2 weeks. It certainly wasn't achievable in 4 working days.
But was the point that that investigation hadn't been conducted made to the
I am, from recollection, I'm almost certain it was, my Lord, but I can't point to a document that you have in front of you. I'm fairly convinced that point was made either orally or in writing at some point. I did put in some written submissions, but they were very brief. But it may be that someone can confirm or correct that. I will show you Dr. Lehtimaki's witness statement in a moment, in which he talks about the available evidence and the analysis which he was doing. Perhaps I could turn to that now, my Lord, my Lords, my Lady, while we're on the evidential position. Could I invite you to take up the core bundle again, tab 14. And perhaps his statement starts at 376. And as I said yesterday, I do invite the court to read this statement. It's not a long statement, and it has the unusual attribute of actually having been written by Dr. Lehtimaki, as is obvious from the tone of it. And it's a very careful, and I would submit sensible statement of a careful man explaining how he's going to approach the exercise if he's allowed to do it. And it may be very different from what the Chancellor was doing, but the Court of Appeal read it, and the Court of Appeal records at the end, this may have jarred with the Chancellor, but we can't see why. It doesn't betray any breach of duty on his part. But what he does is a fairly careful analysis, not only of the economic consequences, but generally of what the effect of the grant might be. And for example, at paragraph 25, he expresses one of his conclusions. The main insight obtained from the above analysis is that, and he emphasises this, if there is no specific information about the new foundation, that's BWP, there is likely to be a significant cost-performance disadvantage when viewed from the perspective of SIF's trustees and members, particularly in the presence of ex-post uncertainty. In particular, the common approach of just considering the amount of monies pledged simply cannot be supported. Any new foundation would have to demonstrate it has a lot more innovative, different, efficient, etc. to overcome this gap. Possible, absolutely, but a hurdle regardless. And then he expresses his tentative conclusions on the grant at 382, paragraphs 34 and 35. He says, the analyses that I've carried out make me think it's very difficult on the currently available evidence to decide whether the grant is in the best interests of SIF's beneficiaries. On the one hand, there is a clear benefit in resolving the historic governance problems and achieving finality. On the other hand, transferring 360 million to BWP comes at a cost. How big a cost is unknown, particularly given the lack of available information in relation to BWP and its very limited track record. It may be large, and that is my biggest concern. And so it is, I submit, a very fair approach to
Before putting this away,
yes, my Lord.
paragraph 52 on 387, Dr. Lehtimaki there accepts he's got a fiduciary duty. You say that he drafted this, no doubt you settled it. Should we pay any attention to the concession of a fiduciary duty there?
I would say no, my Lord, in the circumstances. I can deal with that very briefly. I'll come on to fiduciary duty in a moment. Obviously, he says it. Obviously, he does that on advice. He doesn't know whether he owes a fiduciary duty or not. Again, I would pray and aid the fact that I came into the case at the last minute. No one was seriously arguing fiduciary duty. I should have argued it. I was wrong to concede the point. I did put something in the submissions about whatever the legal position, Dr. Lehtimaki accepts that he owes these duties. But once I had the chance to review it properly, I realised there was a serious point to be dealt with here.
Fair enough, Mr. Morpeth. Thank you.
Thank you, my Lord. But certainly Dr. Lehtimaki's opinion, I would say, takes one nowhere. One's got to actually look at his role.
No.
My Lords, my Lady, the point I started with, which I was addressing here, and I've slightly gone on a siding to, but hopefully a useful one, on a bit of an outing, was to address the point that just because the Chancellor has made his decision, it doesn't follow that Dr. Lehtimaki is bound. And I submit that as a matter of law, that is correct, as a matter of principle, for the reasons I've already given. But it would be a very odd result if Dr. Lehtimaki was bound simply because the members, the trustees had surrendered their discretion and he was then joined in. And as I say, particularly in these circumstances, it puts him in a very invidious position where he is dragged into a hearing at the last minute, doesn't have the chance to make proper submissions or put in proper evidence, and his only remedy, if he is upset about it, is to try and challenge the grant. It's the decision on the grant, which, as I say, is nigh on impossible, given that one is saying that a judge of the experience of the Chancellor had somehow reached a decision that no reasonable judge could have reached on the evidence. And Dr. Lehtimaki doesn't say that. He accepts that there are difficult decisions, difficult factors both ways, but he does say that he has been given by Parliament a right to approve or veto, and he ought to be given the chance to exercise that right. And it's as simple as that. And he's not going to do it in a way that tries to undermine the Chancellor. He's not trying to do it in some way of attacking what the Chancellor has done. He is simply exercising his discretion with his experience and his information, and he wants to do it on full information. And one of the issues that arises, and I'm going to come on to this in fiduciary duty in a moment, one of the issues that arises is there is no guarantee that Dr. Lehtimaki is entitled to get back any of the costs that he spends in doing this exercise. He's doing this entirely at his own risk. It's going to cost him some money to engage consultants to do the analysis of BWP, but he's been with CIF since 2002. He was one of the founding members of CIF. He feels very strongly about the charity, and he's prepared to put his own money into this. And in our submission, far from being condemned as some irritant who is trying to stop the process working properly, he ought to be recognised and commended for the fact that he is actually trying to do a proper job in very difficult circumstances, where through no fault of his own, he's got caught between the fallout of the divorce of Sir Christopher and Miss Cooper. And he's trying to stay impartial and down the middle, but it's not easy. But he wants to do this for the benefit of the charity, and that is essentially why I am here. Well, my lady, I've skipped over a number of points, being conscious of the time. I think I've probably made most of the points I wanted to make on that. I just want to check there's nothing I've missed. I can deal very briefly with the Section 217 aspect of this. I accept that Section 217 does not say in terms it is taking away the court's inherent jurisdiction, and therefore, to that extent, I agree with my learned friend, Lord Panic. My point is rather more subtle than that, and that is that Parliament gave a power to the members, and that is a power that they ought to be allowed to exercise. And that's not taking away from the court's inherent jurisdiction. It's not saying the court doesn't have an inherent jurisdiction if your lordships would and my lady would conclude that it does have one. But it's saying that that is a very compelling factor in not exercising that discretion. And I referred to the Christ Hospital case. I won't go to it again. My learned friend has taken you to it. The short point I'm getting out of that is simply that if there was a power on the part of the court to tell trustees or members how to vote, that is a power that Mr. Justice Chitty could have exercised in that case. He could have said to the governors, I can't do this without your consent under the Endowed Schools Act. I am ordering you to consent. That complies with the letter of the law, if not the spirit of it. And Mr. Justice Chitty didn't attempt to go down that road. The Attorney General, who was promoting the scheme in that case, didn't suggest that it was something that could be done. And in our submission, that again provides some support for the fact that there is no such power, and that it shouldn't, if there is, it shouldn't be exercised where there is a statute giving a right to trustees or members. That was all I was going to say about those points in Section 217. The final point I wanted to make on jurisdiction, before I touch briefly on fiduciary duty, is simply to touch on the wider policy reasons. There is, we submit, a real danger if the wide jurisdiction existed, either under the trust jurisdiction or the charity jurisdiction, that one is going to find the Charity Commission or the courts being harassed by beneficiaries or trustees who are unhappy with decisions that others in the trust or the charity have made. And that isn't simply a view that I'm putting forward. If I could take you to bundle 6, please, of the authorities, just to show some of the commentary that has been made on this. At 6.1, tab 104, MS 2652, this is an article written by Jonathan Fowles of Searle Court, also well-known charity practitioner and author. And he says at 2652 in the right-hand column, commenting on this case, 5 lines down, a wide supervisory jurisdiction would be an invitation to litigation, and given the breadth of a hypothetical jurisdiction based on expediency, the Charity Commission may find it difficult to keep the number of such cases within reasonable limits by refusing authorisation under Section 115 of the 2011 Act. At the very least, the under-resourced Commission would be likely to be deluged with applications for such authorisation. And he makes similar comments. I won't take you to them in the supplement to Tudor, simply to give the reference. It's in Bundle 6, tab 115, MS 2723. I understand those are also written by Mr. Fowles, so probably of limited additional value to see those as well. But there is a genuine concern that this may cause difficulty if there is this wide power to intervene. My Lords, my Lady, that was all I was going to say about the charitable jurisdiction and the trust jurisdiction in Section 217. So unless I can assist on any of those points, I was going to move on then briefly to deal with fiduciary duty. And what I was going to do with fiduciary duty, conscious particularly of the time, is to give you our headline position, particularly on the law. I'm very conscious that Mr. Henderson and Mr. Crowe both developed points on the practicalities and the practical problems that have arisen, or they are concerned about, on the existence of a fiduciary duty. So I'm very much going to deal with the more legal side of it and why we say that the role of members doesn't lead to fiduciary duties, and I will leave my learned friends to pick up on the practical points. We make 3 main points in relation to fiduciary duty. First, that the Court of Appeal's judgment has left the law on this in a state of some uncertainty. And in our submission, there needs to be a principled basis for explaining why, if it is the case, members of a 3-member charity owe fiduciary duties, but members of a 1,000-member or 100-member or 5,000-member charity do not owe fiduciary duties. And the Court of Appeal, with all respect to it, ducks that question.
You say duties. Doesn't the Court of Appeal actually only identify one?
Well, it says that members are fiduciaries, but the duty it identifies is in relation to Section 217, my Lord, yes. Yes, but it leaves and has left, as is evidenced from particularly what Mr. Henderson says, has left uncertainty in people's minds as to what is the scope of the duties and to whom do they apply. And the Court of Appeal says, well, this may not apply to the National Trust with its 2.5 million members, but with great respect to the Court of Appeal, it doesn't actually identify any principled basis for why a 3-member charity members may owe fiduciary duties, but a 2.5 million member charity they don't. And it's really going to be the ones in the middle that are the problem. It's probably not the National Trust. One might be able to come up with some rationalisation for why National Trust members wouldn't owe fiduciary duties, but it's people who are members of a 50-member charity or 100 or 500.
It isn't just the number, is it? I mean, it depends. The question is what powers and or benefits does the constitution of the charity give them? And when looking at the powers, are they under duties in relation to the exercise of those powers?
Oh, absolutely.
And are the duties which they may be under in the charity's powers properly to be labelled fiduciary?
Yeah, absolutely, my Lord. And I was going to come on to that. As the second aspect of uncertainty is what duties are actually owed, because the Court of Appeal identifies a duty and then says, well, there may be further duties, but neither the Court of Appeal nor the Chancellor goes on and identifies what those duties are. So there is serious uncertainty for those who are members of charities as to whether they owe fiduciary duties and what those duties are. And in our submission, the Court of Appeal judgment has left that uncertainty alive. And the reason I focus on numbers is because that is a distinction it's really the only distinction the Court of Appeal suggested, that it may be that large charities, the members don't owe fiduciary duties, but in smaller ones they do. But I say that is not, in our submission, a principled basis for distinguishing, because, as my Lord Briggs points out, it's going to depend on the particular duties. If there are obligations, it can't really depend on the number of members. But it did if SIF appointed another 10 members, do they cease to owe fiduciary duties? Or 50 members? It can't seriously depend on that. But the reason I say it's a general problem is that what the Court of Appeal identified as being the reason for there being a fiduciary duty is the fact that SIF is a charity. It said, therefore, Dr. Lehtimaki must be acting or members must be acting in the interests of the charity to the exclusion of their own interests, and therefore they must be fiduciaries. And so there's nothing specific about SIF, there's nothing specific about Dr. Lehtimaki, which is said to attract the fiduciary tag. And so in our submission, one can't simply do it on the basis that there is a charity. And if it is to be on the basis of the charity, there ought to be some principled reason for saying yes to this charity and no to others, or some guidance, so that members of charities can at least get some advice on whether they owe fiduciary duties or not. Anyway, Lords, I will return to that in slightly more detail. That was the first point I wanted to make. There is uncertainty. The second point is to some extent allied with that, and that is that this is an area of the law which is unfortunately bedeviled by loose language. And our submission is that the fiduciary label ought to be reserved for those who owe the duty of single-minded loyalty, that is identified by Lord Justice Millett in Motho, and who are subject to the rules as to conflict of duty and interest and misuse of position. That is what we submit is strictly a fiduciary duty, fiduciary obligation. And there are cases, there are writings, including Dr. Finn himself in his original work, where the fiduciary label is applied much more widely. In Dr. Finn's original work, he applies the fiduciary label to obligations of good faith. And then in his later writings, he narrows it and suggests what I've just put to you, that it ought to be a much narrower label, although in his yet later writings, most recent writings, he widens it again. And the difficulty is that if one is going to start calling lots of different equitable obligations fiduciary obligations, then the fiduciary label really loses its utility, because rather like applying the word tort to a whole group of wrongs and particular facts that lead to particular wrongs and remedies, calling something a tort doesn't actually tell us whether a particular set of circumstances is one wrong or another wrong, or what the remedy is for that particular set of facts. And if one is going to apply the fiduciary label to everything, to lots of equitable obligations, including good faith obligations, one then has to narrow it down and say, well, yes, it's a fiduciary obligation, but it's an obligation of good faith, which carries with it the remedy of, and then whatever the remedy is going to be, or it's an obligation of loyalty, and that carries with it the remedy of disgorgement. And so in our submission, the better approach is to take the narrow approach, which we suggest comes out of Motho, and I'll take you back to Motho in a moment, and to say the fiduciary label really ought to be attached only to the duty of loyalty, which carries with it the remedy of disgorgement.
As it were, I mean, even Dr. Finn uses it in narrow senses and wide senses, and
yes,
whether you use the label in a narrow sense or wide sense may depend upon the reason why you're asking the question in the first place. In the context of this case, correct me if I'm wrong, we're all asking the question because we're trying to ascertain whether there is some kind of obligation resting on Dr. Lehtimaki, which the performance of which the court can enforce. And I merely wonder, whether it has to be fiduciary in the narrow sense to trigger that ability of the court to enforce. Suppose it's an obligation simply to use his power under Section 217 solely for the purpose for which it's given, and suppose that purpose is to serve the best interests of the charity. I'm not suggesting either of those propositions is right, no. But if that were so, would it really matter whether the duty was also fiduciary in the narrow sense? The court could surely enforce that slightly less rigorous duty if the conduct which it's faced with appears to amount to a departure from it or a breach of it.
It depends what... I respectfully agree with everything your lordship has said, but I think one needs to develop it slightly.
Yes.
It depends on what your lordship means by enforcement. If what you mean is that it's got to be exercised, for example, for a proper purpose, the Section 217 power, and that if it's exercised for an improper purpose, then the court can intervene to either prevent that in advance or to rectify it afterwards, then it doesn't matter whether one calls it a fiduciary duty or not. If what is being said meant by enforcement is that the court can actually tell Dr. Lehtimaki what to do. So picking up on the Letterstead and Brewers type argument that's been advanced and said, because the fiduciary label is attached, it's akin to a trust, and therefore the court can come along and tell him what to do, then obviously I would disagree with that, but it then becomes critical whether it's fiduciary or not, because if one just takes the good faith type example, the more normal example of majority shareholders, minority shareholders, one wouldn't label those as fiduciary duties, even if one would label them as good faith duties. One wouldn't be normal course. And so even if they were labelled with the loose label of fiduciary, and my learned friend was right on his Letterstead and Brewers argument, it wouldn't give the court the right to come in and tell the trustee what to do, but of course the court can come in and tell the trustee what not to do if he's acting improperly.
Doesn't that all lead to the conclusion that the question of whether the label is applied or not is irrelevant?
Well, except that it carries the...
Well, it might be nice to know, I agree, but it's not actually an essential part of the argument, is it?
No, it's important so that one understands the consequences, I would say, my lady, and the only two consequences really in this case are, first, the one I've just outlined, that if the Letterstead and Brewers argument were right, then labelling it fiduciary might give the court the right to come in and tell people what to do. So from that point of view, it's important. Obviously, I say the Letterstead and Brewers argument doesn't get off the ground, so none of that matters. The other reason it could potentially matter and be of great importance to members is that if one attaches the fiduciary label to it, then one is also likely to render the power holder liable for payment of equitable compensation if they breach the duty. Whereas if it is simply a duty to act for a proper purpose, then taking the majority shareholder point of view.
But the question that's before the court is, can the court direct the member to exercise his vote in a particular way? That's the only issue, isn't it?
Yes, my lady.
Yeah.
So this is a further... So in that sense, the label doesn't matter if you're with me on the whole Letterstead and Brewers argument. Doesn't matter if you're against me on the charitable jurisdiction argument, because then the Letterstead and Brewers doesn't matter, and you don't need the trust to be able to tell Dr. Lehtimaki what to do. Where it does matter is if you're against me on Letterstead and Brewers, and this is an alternative. This is the only way of directing Dr. Lehtimaki how to act. So on the simple question of whether one can direct Dr. Lehtimaki, that's the only circumstance in which it matters. But it does also matter for the wider consequences, that from Dr. Lehtimaki's point of view, when he's exercising his power, is he going to be faced with a claim for $360 million worth of equitable compensation or some smaller sum? Or is it simply the case that if he's found to exercise his power improperly, that the approval or veto is set aside? So it does have a practical consequence for him, and I would say for other members as well. But it is just a labelling point. We entirely accept the obligation. It's the consequences that come with calling it fiduciary if one's using fiduciary and carrying with it the remedy and the power of control. That's what really matters.
I think the obligation you entirely accept, but please correct me if I'm wrong, is that the Section 217 power has to be exercised by the members solely in accordance with what best serves the interests of the company.
Yes, yes, my lord. Yes. As I said, it is really a question of labelling. We would urge you to confine the fiduciary label to what I've described as the narrow fiduciary duty for the reasons I've given, but otherwise one has to go on and identify what one means by that particular fiduciary duty and the remedy that goes with it. If I could just take you briefly to Mothu once again. It's in Bundle 1, tab 10, MS 650. 650 is the passage that my learned friend showed you earlier, and I won't read through it all again. But Justice Millett says there the distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to single-minded loyalty of his fiduciary. And we say that is the overriding obligation of the fiduciary and what identifies the fiduciary, and why in a moment I will say that members of CIF and members of charitable companies do not owe that single loyalty. And I'll develop that in a moment as my final submission on the evidence. The other passage I want to show you is the next page, page 651, at D to E. And Lord Justice Millett says, even if a fiduciary is properly acting for two principals with potentially conflicting interests, he must act in good faith in the interests of each and must not act with the intention of furthering the interests of one principal to the prejudice of those of the other. So that's a normal interest of good faith, and he says, I'll call this the duty of good faith. But it goes further than this. He must not allow the performance of his obligations to one principal to be influenced by his relationship with the other. He must serve each as faithfully and loyally as if he were his only principal. So where someone is a fiduciary owing an obligation of good faith, it is an obligation to serve loyally as though that were the only principal. Now, in a case such as Bristol and West and Mothu, obviously it's possible to act for two principals because there's informed consent on each side. Unlikely to be possible in that same way in relation to charities, because there's no one to consent, unless one gets the consent of the Attorney General on each occasion. I do say in passing that last sentence identifies some difficulty with one of the propositions that's been put forward by the Attorney General. He has invited the court to clarify that it is not a difficulty for members of charities to be members of two charities with the same objects. It seems to us that this actually identifies a difficulty with that, because it's difficult to see how, if one is a member of two charities with the same objects, that one can serve each as though they're your only principal. And if one took the example of someone who's a member of two local charities applying for funding, where there's limited funding from a local business or a council, it's very difficult to see how one could, with the two hats on, act for both charities. But no doubt the learned friend will develop his point. I simply make that point in passing. It seems to identify a difficulty with classifying members as fiduciaries, rather than being something the court should be invited to endorse.
Before we leave Mothu, can you just remind me, why did it matter in that case whether the admitted breach of duty, because the solicitor admitted, I think, the breach of duty was a fiduciary duty? It wasn't a question of a court exercising a power to control the fiduciary in the performance of the duty. It was a monetary question.
No, it was the remedy that could be obtained
Yes.
in return for being, if they were a fiduciary, then there was a remedy, and if they weren't, then they had to go on and consider, was there a remedy for breach of trust, and what was the remedy? It was a much easier remedy if it was fiduciary. There was, I think, it was either tracing or an account. I think it was an account, whereas otherwise one had to go through the exercise of calculating damages or equitable compensation. Sorry. So it's or in tort and negligence, Mr. Henderson reminds me. I've referred you in my written case, but given the time, I won't take you to the F&C Investments decision. It's some way off these facts, because that was a case about partners in a limited liability partnership who necessarily were, to an extent, acting in their own self-interests, and that was part of the reason why they weren't fiduciaries. But one of the points that comes out of that, and I've put the references in my written case, is that a question to be asked is, has someone taken over the assets of someone else which they're managing for them? And Mr. Justice Sales, as he then was, said that the partners were not fiduciaries, partly because they didn't have any control, direct control, day-to-day control over the assets of the partnership. And that's similar here, where in the memorandum, the articles, Article 3.2, it is specifically provided that it is the trustees of CIF who are the ones who hold the assets of CIF, the property and assets. The members do not hold the property and assets. And that was the reason why the Chancellor concluded that the trustees were charity trustees, but the members of CIF were not charity trustees. The final point I wanted to make on the law is that on the authorities, we submit that it's not enough simply that one is acting in the interests of someone else to make you a fiduciary. My learned friend, the Attorney General, Mr. Pearce, for the Attorney General, says that the members of CIF are acting in the interests of CIF and required to act only in the interests of CIF, therefore they are fiduciaries. In our submission, that isn't enough. Simply acting in someone's interests doesn't make you a fiduciary. And I gave the example in my written case of the homeowner who engages the plumber. The plumber is acting in his interests. The homeowner is entrusting a great deal of faith and trust in the plumber, but no one would suggest that the plumber owes fiduciary duties. So there's got to be something more than that to give rise to a fiduciary duty. And there's an article that we've put in the bundle. I commend it to you, but I won't take you to you. It's at bundle 3, tab 52, MS 1734. It's a short and illuminating article by one of my learned juniors, Professor Worthington, which is only a few pages long, and I do commend it to you, but it contains two important points. One is that point, that it's not enough simply to be acting in the interests of someone else to make you a fiduciary. And the second point that she makes is that fiduciary duties ought to be imposed where they are necessary because of the consequences of what comes with them. They are a sledgehammer, she says, and one shouldn't simply be imposing them where other duties are sufficient. And that is really the essence of our case, that the existing law is sufficient, the requirement to act for a proper purpose, and the requirement to act in good faith, which the law already imposes on power holders, is sufficient protection for CIF. And it doesn't need to be treated as a fiduciary duty, carrying with it the consequences that come with that label. The final point I wanted to make on the evidence, really, or the role of members, is this, that to be entitled to single-minded loyalty, and that's the word Lord Justice Millett uses, that entitled to single-minded loyalty, there needs to be a good reason for requiring that and for entitling CIF to have that. CIF needs to be giving something in return, or giving sufficient in return for the members to claim that entitlement. And in the case of a charitable member, I see my Lord Briggs looks puzzled at that suggestion, but it may seem a slightly odd one, but the reason I put it that way is that one can't simply cast the members out and say you are fiduciaries and now you've got to exercise fiduciary duties. The charity needs to be giving something in return, and what it needs to be giving is information and protection, because an important part of being a fiduciary, if members are, is that they've got to consider whether to exercise their powers, and to do that they've got to have the information and the resources to consider that properly. And that's why I say the charity has to give something in return in this sort of case. If members of charities, corporate charities, are fiduciaries, when they get their annual general meeting notice in the post, they can't just chuck it in the bin and say, I'm not going to deal with it. They've got to act like fiduciaries and think, do I want to vote on any of these resolutions this year? What information do I need in order to vote on them? And the grant is a perfect example of that. Dr. Lehtimaki, if he is a fiduciary, has got to have the information on which to make a proper decision, a properly informed decision. And he ought to be given some protection against the consequences of that decision if he is potentially liable for open-ended equitable compensation if he gets it wrong. The trustees are insured. They're allowed to be insured under the Charities Act. They're allowed to be insured under the Articles and Memorandum. Dr. Lehtimaki has no insurance, and there's no right under the Charities Act or under the Articles of Memorandum for him to have some. But it is, in my submission, quite wrong for members to owe fiduciary duties and be faced with those sort of potential liabilities and yet have no protection, whereas the trustees are entitled to and do.
Might it be said it's odd of Parliament not to have conferred rights to information on members in connection with Section 217 resolutions, if Section 2.1 resolutions have the importance which you have attached to them. Because there is no right in a member of a company to go and look at the company's records or to require the company to pay for an expert's report.
Well, subject to the fact, my lady, that, of course, the member holds the whip hand on Section 217, and the member can say, unless you give me the information, I simply can't make a decision on this.
Well, it's a question of legal rights I'm talking about.
Yes, he may have no right to it, but he can say, well, look, if you don't give me the information, I'm going to have to vote no, because I can't authorise whatever it is, £1 million, $360 million, going out of the charity unless you justify it to.
It still seems odd to have a statutory scheme with no right to information.
But there is a practical solution there, my lady, that the member simply says no if you don't give me the information. So in my submission, it's unclear why Parliament didn't provide for information, but there is an easy solution in those circumstances, and there's no hole in it. My lords, my ladies, conscious of the time, I'll wrap things up. I think I have said all that I wanted to say on fiduciary duty, and no doubt those who are dealing with it after me on the practical points will pick up on any practical points or legal points I've missed. So unless I can assist further on anything, those were my submissions.
Could I ask a very quick question?
Certainly, my lord.
It's been crossing my mind whether if this appeal were to be dismissed, your client could be removed from membership, depending upon the way in which he reached his decision. So could we go quickly to the Articles of Association again,
Certainly,
which are behind tab 22?
Yes.
You will recall that under 1.5, membership is terminated if the member concerned, 1.5.4, is removed by resolution of the trustees on the ground that in their reasonable opinion, the member's continued membership is harmful to the charity. So the trustees have a discretion to remove a member if they have that reasonable opinion. Could the trustees, as they have already in this case, relinquish that discretion to the court?
One would have to come within the confines of public trustee and Cooper that there is a reason for them relinquishing it, which is normally, I didn't answer Lord Reed's question as carefully as I could yesterday on this, but it does say in public trustee and Cooper, where my learned friend took the court to yesterday, that there needs to be a reason for the courts to intervene. And it's usually that the trustees can't act, or that there is a conflict or some such reason. They aren't allowed to just come to court and give up their discretion for no reason. But in the right circumstances, then there would seem to be no reason why they couldn't relinquish that to the court in the same way as any other discretion.
Quite apart from 1.5 and the facilities for termination of membership, has the court got any independent jurisdiction to terminate the membership?
Well, it could probably do so on the Lettersted and Brewers type jurisdiction if those requirements were met. Don't see. Suppose it would depend. Well, it would depend on them being fiduciaries, and the Charity Commission would probably be able to intervene and remove him as a member. But I mean, the reality is, if there was genuine concern as to Dr. Lehtimaki's impartiality, he would not be standing in people's way. I mean, he has been exploring the possibility of other members joining SIF, and he is not wedded to making this decision himself.
Thank you.
Thank you, Lord.
Thank you very much, Mr. Morpeth. Mr. Henderson, or is it Mr. Crowe?
I think we had agreed that I would go next, my lord.
Very well.
And I'm conscious of the time and conscious of the amount of material to get through. I will, I'm afraid, have to be going at quite a speed in the hour and a quarter that's been allocated to me. The only consolation I can offer is that there is a transcript. So if I'm giving you what appears to be quite a long reading list, at least your lordships will, and my lady will have the transcript to refer back to after the event. What we were proposing to do is to deal with essentially the four issues that have been discussed in front of you. The two issues that are identified in the Statement of Facts and Issues, which is, do members owe fiduciary duties? Second, did the court have the power to direct this member how to vote? I will then also deal with what my learned friend Mr. Morpus calls Lord Panic's third argument, which is one he was opening on this morning on the question of whether or not the court has simply decided something for the company and therefore the member doesn't have a function at all. And very lastly and very briefly, I will just say something about the position of Sir Christopher, which is the last tail end point in my learned friend Lord Panic's written case. I was going to deal very first with the third argument, just to add a couple of points to what my learned friend Mr. Morpus has already said on that this morning. As we understand the argument, the suggestion is that the Chancellor has decided that paying the grant is in the interests of SIF as an entity. The directors and the members are two organs within that single legal person, and that therefore there is nothing more for the members to decide. I entirely adopt what my learned friend has already said on that. I would simply add this, which picks up and develops very slightly some of the things he said. First, simply as a matter of form, to underline, I think you probably already have it, but to underline the fact that as a matter of form, the members, one organ of the company, did not surrender their discretion to the court. Not only was Dr. Lehtimaki not a claimant asking the court for anything, he wasn't even a party when the proceedings were issued, and it was the proceedings in that original form that the Charity Commission agreed should be brought. Second, just picking up on the Shaw and Shaw authority, the directors could not, as a matter of internal company constitutional law, surrender the members' discretion to the court. It is axiomatic in company law, leaving charity law aside, it is axiomatic in company law that the members cannot arrogate day-to-day management if it's delegated to the directors, and the directors cannot usurp the powers that are delegated to the members, a fortiori, where it is not just a matter of internal company administration that this particular power is delegated to the members, but it is a matter of express statutory enactment under Section 217. So the directors could not surrender the members' discretion to the court. And the third point, just on form, is that the Chancellor was not being asked to give any direction ordering Dr. Lehtimaki how to vote, or obviating the need for him to vote. I don't ask you to go to it now, but in due course, if you look at the relief sought in the claim form, which is in tab 8 of the core bundle at page 322, and if you look particularly at paragraphs 1, 2, and 9, it is absolutely clear that what was contemplated in the proceedings was that there would be a need for a free vote under Section 217.
1027 just about covers it in a catch-all way, doesn't it?
Well, that is directed to directions which we submit can only have meant formal directions for the holding of the meeting, not orders as to how to vote. Not least because Dr. Lehtimaki wasn't a party, and 1027 is only directed towards directions to the claimant and the defendants, who were the company, Miss Cooper and Sir Christopher, and the Attorney General. So 1027 cannot have been read or intended as inviting the court to exercise any sort of power to make orders against a non-party.
As a matter of history, had the Section 217 point, as it were, reared its ugly head by the time the claim form was settled?
Oh, yes, absolutely. It's all over the claim form, and indeed. So that's the first point.
Have you got a transcript number for it?
I'm sorry?
Have you got an MS number for the claim form?
322.
Thank you.
Secondly, still on this same point, turning to a matter of substance, with respect, the argument that is being floated here in our submission simply doesn't stand up, and it isn't really an argument in answer to the legal issue that is raised in the appeal. On analysis, it is really just a different way of restating the same question. It is true, yes, the Chancellor did say that he considered the grant to be in the best interests of SIF. But that simply raises the question you were asked to decide, which is, did and can the court's ruling on that point bind the members. So simply to say the judge made, the Chancellor made a decision as to what he considered to be in the best interests of the company, we submit simply restates the legal question that you have to answer, the main legal question, which is whether the court could bind the members. And ancillary to that, it's a third point or just an add-on to the previous one. There is a good reason why this line of argument cannot answer the legal question that is raised. And that is, to pick up what my learned friend Mr. Morpus was saying, which is that the question whether or not paying the grant is or is not in the interests of SIF is a matter of opinion. It is not one of those questions to which in law there is a right or a wrong answer, and that is precisely why the Chancellor himself expressly recognised that different people might reasonably reach a different conclusion. So, yes, it is entirely true that the Chancellor felt very strongly that he had come to a correct answer, but he acknowledged that others could come to reasonably different answers. Now, with that on board, and with a legal structure under which Parliament has put in place a three-tier regime for making payments, if at all, for loss of office, which will involve the directors deciding to do it, the Charity Commission agreeing to let it happen under Section 201, and then the members under 217 approving or not. In our submission, for it to be said that there can only be one answer simply because the directors of the company asked the court what the court thought, simply in our submission cannot provide an answer to the legal question that you're asked, which is, does that decision eliminate the need for the other two stages in the statutory regime to be gone through? Full marks to my learned friend Lord Panic for his courage and his consistency in acknowledging that the logic of his argument leads to the conclusion that the court can tell the Charity Commission how to decide. But the fact that he has to concede that that is the logical conclusion of his argument, in our submission demonstrates the exorbitant reach of the argument he is advancing in front of you, because he is having to acknowledge that not only does, well, Parliament has put in place a regime for companies generally under 217. It didn't just leave it in place for charitable companies by accident. It put a further layer of regulatory control in it by saying not only does there have to be the 217 resolution by members, there has to be prior Charity Commission approval under Section 201. My learned friend's argument is to say that in that three-layer structure, as I say, with company decision, i.e. director's decision, Charity Commission consent, members' consent, by the directors surrendering their discretion to the court, he's having to say that the other two elements which Parliament intentionally put in place in relation to charitable companies have been obviated. And in our submission, once you do face up to the extravagant nature of the consequences of his legal argument, in our submission it does demonstrate that the argument is unjustified and
Parliament enacts legislation against the backcloth of the general law, does it not?
Yes.
So if the court has an inherent jurisdiction in relation to charities, which is wide enough to cover directions, then the fact that Parliament has not said so in the Charities Act 2011 would not affect the presence of that jurisdiction.
My lady, there are at least two answers to that. The first is that it assumes, well, in fact, there are two aspects of the same answer. To put the point in that way assumes that there is an answer to the first and main question, that the court does have an unlimited jurisdiction to order.
I made that clear, yes.
Right. Our answer to that is that it is a wrong approach to the assessment of the court's jurisdiction to reach a view on that and then look at Section 217. What is perfectly clear, and you get this from a couple of the cases that are in the authority, I was going to go to them later, but I'll mention them now, both in the decision of Coates and Gilmore, and in the CITB, the Construction Industry Training Board case, you get express recognition that the scope of the court's inherent jurisdiction is constrained by parliamentary law. So when you are looking at the contours in order to identify the limits of the jurisdiction, the court's inherent jurisdiction, you do have to look at what legislation is in place.
We would be going to post.
I'll give you the page references.
So we could do
My learned friend's answer to that is that children's case, re S. And in our submission, that is absolutely nothing to the point, because if you look at what had happened in that case, the question was that the court had ordered a child to be a ward and then decided to withdraw that order. So the court was abandoning its jurisdiction in relation to the child. It was entirely, but the order that was under appeal was an order cancelling the making of the child as a ward of court. So where, as my learned friend read you with a short passage saying that the jurisdiction of the court, the inherent jurisdiction of the court as parens patriae, cannot be taken away without express enactment, what it was talking about was a situation in which what was being argued for was the complete abdication of the inherent jurisdiction.
But that doesn't affect the general point, does it?
That is an entirely different point from what we are arguing about the effect of Section 217. Nobody is suggesting that the court has lost whatever inherent jurisdiction it has in relation to SIF. All we are arguing about is where the frontiers of that inherent jurisdiction are. And answering that question does require you to take into account the fact that Parliament has intentionally put in place a tailor-made regime for charities in relation to Section 217.
The jurisdiction we're talking about stems from the Crown's prerogative powers over charities.
Yes.
So the court is implementing not a jurisdiction over trusts, but is implementing the prerogative power of the Crown in relation, as parens patriae,
Yes.
in relation, in this case, to charities.
Yes.
Therefore, doesn't the general point apply that you'd need express wording to remove a prerogative power of the Crown?
It's not removing a prerogative. That's
Diminishing.
the re-S point. The Parliament plainly can constrain the exercise of the prerogative by legislation. And the argument is not the point that was run in re-S, that the prerogative is being abolished in an area which it was previously available. The argument is simply that the prerogative is exercisable within the constraints that are left by the general law, by statute law.
Mr. Craig, I entirely accept your picture of a structure under which first the trustee directors and then the charity commission and then the members have to consider a transaction of this kind where Section 217 applies. It's unlikely, isn't it, that Parliament was as concerned about those layers where the first stage in the process is conducted by the court than if it's merely conducted by the trustees?
One can entirely see as a matter of policy why Parliament might have taken a view that a further layer in the bespoke regime might have been put in place to say that Section 201 of the Charities Act and Section 217 of the Companies Act don't apply if an application is made to the court. But where Parliament has made express statutory provision, in our submission it is not appropriate for the court simply to say, well, that's all very well, but I know better. And that is essentially what the Chancellor was saying. Final point, I don't want to spend too long on this because it was meant to be my sort of 2-minute introduction. The final point is simply to answer one of the observations that came from the bench, which was that Dr. Lehtimaki is taking the same decision as the Chancellor. And if we could just echo but add to what my own friend Mr. Morpus has said on that. With respect, he's not actually answering the same question, and he's certainly not answering it from the same perspective, or with the same skills, or with the same information, or at the same time. He's answering a question under Section 217 as to whether SIF should make a payment for loss of office, whereas, as we've seen from the Chancellor's judgment, the Chancellor was taking into account the wider interests of the charity sector generally, which included additional funds going into big win philanthropy. Plainly, for that reason, Dr. Lehtimaki is taking a decision from a different perspective because he's taking it from the perspective of a company member, and he is answering as someone who was not a party to the contracts. As my learned friend Mr. Morpus pointed out, Dr. Lehtimaki was not a signatory to the contracts under which the grant was agreed to be paid, and therefore that factor which the Chancellor took into account it does not apply to him. He does inevitably have a different skill set and different information available to him, a fortiori, because he's now taking, in the events, a decision some years after the Chancellor did. Intervening events will have happened. Big Win Philanthropy may have done X, Y, and Z to demonstrate that it's a fantastically deserving recipient, or it may have done very little, and Dr. Lehtimaki may reach a different view. But it is simply not right to say he is taking the same decision on the same information. With that on what has been called the third point, what I was going to do in order to keep some sort of structure to our submissions, I'm just going to run through our case and pick up a few points by way of addition. So if I could invite your attention to page 199, MS 199. I'm going to deal with them in the same order as my learned friend Mr. Morpus, because obviously the question that really matters is, can the court direct Dr. Lehtimaki how to vote? I will spend much less time on fiduciary duties. So I'll start in the middle of our written case, paragraph 21, where we point out the two sort of contextual elements that you've already got well on board. So 21.1, we remind you that the decision that the Chancellor took, he recognised was one in relation to which someone else could responsibly and reasonably reach a different view. And we've already made the point in 21.2 that the Charity Commission authorised the proceedings to be brought in which Dr. Lehtimaki was not a party, and that is, I think you were taken to it, but the authorisation by the Charity Commission which sets out the parties and the relief that it is authorising to be sought is in tab 23 of the appendix, which is MS 447. I don't ask you to go to it now, but it is helpful to look at that because it shows, as I say, paragraphs 1, 2, and 9 in particular of the relief, the nature of what the court was being asked to do. Moving over the page, paragraph 22, we point out at 22.1, it is striking that despite the industry and learning of her three leading counsel, she has been unable to cite a single precedent to support the proposition. A somewhat vain attempt in our submission was made to suggest, well, an awful lot of these cases get decided in a way that doesn't get reported. It is, with the greatest respect, impossible to suggest that the court has ever exercised a power to direct a trustee, let alone a company member, how to exercise his vote absent a threatened breach of trust without it getting into the law reports in the last 400 years. It is just not a plausible line of argument. It is not a situation in which some deep-sea creatures have been living unobserved for centuries and have only just been noticed. The fact is that this is a jurisdiction that doesn't exist. It is not a discretionary power that the court has simply chosen not to exercise for 400 years. It is not a power the court has. And the essential reason for that, and this is the conceptual point that runs through quite a lot of the argument, the essential reason is that the court's jurisdiction in relation to charities is proscriptive, not prescriptive. It is a power to supervise. It is a power to put in place machinery if necessary. It is not a power to manage. The court never takes managerial decisions in relation to charity trusts. And In parallel, the Charity Commission is expressly, as my learned friend pointed out, under Section 20 of the Charities Act, the Charity Commission is expressly prohibited, we say by analogy with the position of the court, from undertaking the management of charities. There is a conceptual difference between the court either preventing breaches of trust or at the most putting in place machinery through a scheme and then handing over management decisions to trustees. There's a clear conceptual difference between that and the position for which my learned friend is seeking to argue, which is the court actually engaging in management decisions, imposing its own discretionary decision-making over that of the duly appointed decision-makers, absent the threatened breach of trust. And that is the essential difference, and that is why we submit that my learned friend Lord Panic's argument is wrong when he says, well, if the court has this scheme-making power, which is very big, it's perverse that it shouldn't have a lesser power, which is simply to tell a trustee, or a member in this case, how to behave in a particular case. That has a superficial attraction in one sense until one recognizes that the two powers are not little and large. They are in conceptually different boxes. One of them, the scheme-making power, is the court's power to put in place a mechanism under which decision-makers are appointed, who then take the decisions. The court in that context is not taking decisions about the management of the charity. Repeatedly, the case law says, it's not for us, the court. What my learned friend is seeking to argue for, which is unprecedented, is the idea that the court should simply usurp the decision-making function of the duly appointed decision-maker in one particular context for one particular purpose. And in our submission, as we say, that is the reason it is unprecedented, is that it is not a jurisdiction the court has, and it is not a jurisdiction the court should invent. It has been suggested that the court can develop its case law, that the law can evolve. This would not be an evolution, this would be a U-turn, because it would involve the court meddling in management decisions, which it doesn't do, either in the charities or in the trust context generally, or in company law. So that is our 22.1. 22.2, we also urge, there has been evidence of this in the course of my learned friend Lord Panic's arguments with respect, a dangerously imprecise use of language. In order to fuzzify the boundaries of the jurisdiction he's suggesting, he has simply been talking about a broad jurisdiction. In our submission, that doesn't help. Indeed, it's worse than that. It serves only to confuse, to talk about a broad or narrow jurisdiction. It's not a question of broad or narrow. In order to raise a question and answer it, the court has to identify what are the principles by reference to which the jurisdiction actually exists, and by reference to which it can properly be exercised. And that's not a question of saying, well, it's big, and therefore making it a little bit bigger doesn't really matter. The principle is that the court doesn't involve itself in management. The court can apply schemes funds C. Prey. It can put in place management decisions, management structures. It can restrain breaches of trust. Letterstedt and Brewers, it can remove trustees if it's necessary for the due administration of the trust. That's the highest my learned friend has been able to find a case to go. Necessary for the due administration of the trust. Usurping Dr. Lehtimaki's decision under Section 217 is not necessary for the due administration of this trust, precisely because the Chancellor held that a decision either way by Dr. Lehtimaki would be reasonable and would not involve a breach of trust. So it is not necessary for the due administration of the trust for the court to force the answer on Dr. Lehtimaki. There has been some discussion and some suggestion from my learned friend Lord Panic that the grant was ordered, the grant was agreed, the settlement was reached because of the governance problems. The two things that you do need to keep in mind, one has already been pointed out, the governance problems are historic. You saw the letter. They were solved by the entering into of the settlement agreements. And it is an important feature, which you may already be aware of, but I would just wish to remind you, it is an important feature of the settlement agreements that were reached in 2015, was that Ms. Cooper is resigning, irrespective of whether the grant is paid. If we can just look very briefly for this one, I'm not going to go to many documents, but just in the appendix tab 16, MS394, is one of the documents that went to make up the April 2015 agreements. And if you go to the second page of it, so MS395, 6 lines before the end of the first paragraph, Jamie Cooper will resign as a trustee and member of SIF UK with immediate and permanent effect on the determination in respect of the proposed grant by the Charity Commission, Tribunal, Court, as the case may be, and for the avoidance of doubt, this will occur whether the proposed grant has been approved by such body or not. So, my learned friend's attempt, my Lord Panic's attempt to say, oh, well, this case could have been put through as a scheme application, in our submission is wrong at the two levels that point would need to be analysed. As we heard from my learned friend, Mr. Morpus, and we entirely agree and support, the precondition to making a scheme is that the machinery of the trust is broken. The machinery of SIF is not broken. It wasn't broken in front of the Chancellor because the settlement had been reached, the governance issues were behind, and Ms. Cooper will resign, effective on the final determination of the grant, yes or no, by the court. And the second reason why this could not have been, this application to the court could not have been packaged as a scheme, is precisely the conceptual difference that I've already urged on you, is that a scheme is an expression of the court's power to put in place a machinery for the management of a trust. It is not an expression of any supposed power on the part of the court to direct the exercise of discretionary judgments in individual cases. That, I hope, assists in relation to why we urge the point under paragraph 22.2. Turning then back to our case on page MS200, we say that in my learned friend Lord Panic's case, there are essentially two stages in the argument that he's advanced. There's sort of a general one that the jurisdiction in relation to charities is somehow unlimited, and then there's the specific one. This is looking at para 23. Then there's the specific argument in relation to the supposed power to direct members of a charitable company how to vote. And answering those points, we point out at 24.1 that simply to refer to the court's inherent jurisdiction in relation to charities merely identifies the source of the power. It does not define its scope. It is dangerous and wrong to think that because a power in the court is inherent, it is therefore unlimited or unprincipled. In our submission, the inherent jurisdiction in relation to charities is both principled and limited, essentially in the way that I've already described. And if we look then at our paragraph 24.2, we say that if you run through the case law, and I'm not going to do that because time is not available, but I just do want to take you to two of the authorities that underline the point. You've got them. I apologise for the way we've had to deal with it in our case. They are condensed into a lot of footnotes. But there are two cases not mentioned in our footnotes which the other parties have cited, and it is just convenient to look at a couple of lines in two of them. The first is the Attorney General and Bishop of Worcester, which is in Authorities Volume 5, if you're working in the hard copy. Sorry, Authorities Volume 1, tab 5. If you're in hard copy, and it's MS 573. The facts don't particularly matter. It was an information laid in relation to Kidderminster School, and various issues arose about the exercise of the court's scheme-making power. And the particular legal issue that arose was the ability of the court to amend by scheme a scheme that had previously been settled by the court. The reason I just wanted to take you to it, if you go to MS 590, internal page 547, while you were reading all other case law that my learned friend wishes to rely on, could I ask you to keep in mind in the first complete paragraph, 7 lines down, the court says, incalculable mischief will ensue to all the charities in the kingdom if this rule be not strictly observed, and if the court ventures in such cases to interfere upon speculative views as to what the results of alterations or in matters of discretion or regulation, matters on which opinion of succeeding Attorney General and of each succeeding judge may well be permitted to differ. Incalculable mischief will ensue if the court ventures in such cases to interfere in ... matters of discretion or regulation. That is a clear statement of the principle on which we rely, the non-intervention principle, as the Attorney General calls it, that the court does not involve itself in matters of judgment, in management. It involves itself at a structural level by making schemes, and it restrains or grants remedies for breaches of trust. And the other passage I would just ask you always to keep in mind is in the case of Steed, which is in Authorities Volume 5, if you're in hard copy at tab 90, and electronic MS2405. Again, the facts don't particularly matter, but the question that happened to arise in that case is whether or not trustees should be restrained from selling a farm, which the beneficiary didn't want to be sold. In that context, if we go to the last page of the judgment, so internal page 362 and MS2413, again, just in the main paragraph, so almost exactly in the middle of the page, the sentence beginning, in my view, it would not be right where responsible trustees, clothed with this kind of delicate and difficult discretionary power by the testator, wish to exercise it in a certain way, for the court to say, I know better than you, and override the exercise of your discretion. That is, with the greatest respect, exactly what the Chancellor did in this case. And he shouldn't. As a matter of jurisdiction, it's not what the court does. In this context, it's important to mention my learned friend Lord Panic latches onto the use of the word expedient in some of the cases. It pops up in Lang, and it pops up in the Construction Industry Training Board. And he latches onto the use of the word expedient in some of these cases, and he says, aha, this is what defines the scope of the court's jurisdiction. With the greatest respect, that is a misreading of what those cases are doing. The word expedient describes the test which the court applies when it's deciding whether to exercise a jurisdiction that it does have, such as to make a scheme, to remove trustees. But mere expediency is not the foundation of the jurisdiction. It doesn't define the jurisdiction. The court can't simply do whatever it wants in relation to charities because it's expedient. And exactly that wording, mere expediency, is not enough to found the jurisdiction, is what was said in the case my learned friend took you to yesterday, Chapman. I won't go back to it, but it's Authorities Volume 1, Tab 11, and it's electronic MS 677. Expediency is not enough to found the jurisdiction.
But is that dealing only with private trusts?
My lady, the difference between private trusts and charitable trusts is, as the case law shows, that in relation to charitable trusts, the court has all the same powers as in relation to private trusts, with the add-ons of the ability to apply funds C prey, with the ability to make administrative schemes if the machinery is broken, and with the ability under public trustee in Cooper to exercise the discretion of trustees if the trustees have sufficient grounds for surrendering, and they do surrender, or apply for a momentous decision to be sanctioned. There is no case law to suggest that in relation to charitable trusts, the court has a different jurisdiction at a sort of management decision-making level. That is, in our submission, heresy, and it would not involve, as I say, an evolution of the law. It would involve a U-turn, and it would be a retrograde one for all the reasons that we go to in our case. Just in relation to that, there are some very useful passages in the case law which I don't have time to go to, so could I do what I threatened to do and simply give some references and invite you, while you're considering the matter, to consider the Harrow School case. I'm dealing with these in chronological order, starting in the mid-18th century. So the Harrow School case, Authorities Volume 4, Tab 66. The relevant passage is at MS 2018. 40 years later, the Haberdashers Company case, Authorities Volume 4.
Can I ask, are you taking us through the cases in your footnote 51?
I think
if you are, that might be a quicker way of our...
Yes, I was going to add a couple in just to give you a single run. It is largely that, but so yes, the first one is indeed Harrow, the second one is Haberdashers, and the third one is the Foundling Hospital, so yes to all those three. Just taking it in chronological order, because I think that there are two academic works, the Chitty on the Prerogatives of the Crown from 1820, which we mention elsewhere. It may be useful to insert in the same run, which is Authorities Volume 6, Tab 102, page MS 2637. And there's a very good and very clear statement in Story's Equity Jurisprudence, which is Authorities Volume 6, Tab 112, at MS 2705. And then you've already seen beloved Wilkes, but could I then invite also, which is not in that footnote, could I invite you to look at the Sherborne Grammar School case, which is Authorities Volume 1, Tab 8, and the relevant passage is MS 624. And finally, the last letter stead you have seen, when you are looking back particularly at MS 825 in Letterstedt, you will see that the decision is being taken to exercise a power, a jurisdiction, which the court has, that is, to remove trustees, and it was considered expedient to exercise that power on the facts of that case because it was necessary to see that the trusts are properly executed, is the words at MS 825. And we submit that that is the correct criterion for the exercise of a jurisdiction that the court does have. Mere expediency doesn't confer a jurisdiction. And finally, we get very similar language in the Construction Industry Training Board case, which is Authorities Volume 1, Tab 12, and the relevant passages are on 715, MS 715 and 720 to 721. So we then move on in our case, if we go back to 202 of the MS 202, and we explain the arguments that the positive case that we advance for saying that the court doesn't have this jurisdiction in paragraph 27, and just running through that, you'll remember the structure of it, but I just want to expound on a couple of the points. The starting point, I don't say this is the ending point, it's the starting point, is 27.1, the position under company law. It is self-evident that the court does not have a power to direct members of a non-charitable company how to vote. So the question is, does charity context produce a different answer? In relation to the inherent jurisdiction, I've already outlined what we say you get from the cases that we're inviting you to consider. And in relation to 27.3, the scope of the court's scheme-making power, again, I've already outlined what we submit you get from that. What I do want to expand upon is in 27.4, which we'll come on to in a little moment, which is the various practical and policy considerations that we say should be borne in mind in this context. And I'll also just say something very briefly about 27.5, the public law analogy. So we can move on quickly to the next page, paragraph 28. I don't need to add anything there.
Just pausing,
yeah.
in relation to the Companies Act, there would be power in the court under section 994 to direct a member how to...
Yes.
Right. There are specific...
No, that's absolutely right. Yes, if the preconditions to that jurisdiction were in place, indeed so. So 28.1 and 28.2 I've already covered, and I don't need to go into that further. The written case and the footnotes provide the argument. We then develop, again, in stages, not suggesting any one of these stages answers the point, but the evolution of the argument comes in stages. So the position in relation to the directors of charitable companies is that although a director is not in a strict sense a trustee, I'm reading 28.3, of a company's assets, and a charitable company is not in a strict sense a trustee of its own assets, they are in a sufficiently analogous position to that of a trustee of a charitable trust for the court to exercise in relation to charitable companies the same inherent jurisdiction as in relation to charitable trusts. Now, we've footnoted there the case of Liverpool District Hospital. It is convenient just very briefly to look at that one because there's a passage quoted in my own friend Lord Panic's case which stops at what we would say is an expedient point for his argument, and I would just like to draw to your attention the rest of what he said. So in Authorities Volume 1, Tab 20, the case starts at page 833, MS 833. The passage talking about the position of directors of a company being in a position analogous to that of a trustee is at MS 849. And I don't need to dwell on that. We get that from on 849 between letters E and H. But if we can then move forward to MS 854, you get the passage at letter B. In my judgment, the so-called rule that the court's jurisdiction to intervene in the affairs of a charity depends on the existence of a trust means no more than this. The court has no jurisdiction to intervene unless there has been placed on the holder of the assets in question a legally binding restriction, arising either by way of trust in the strict traditional sense or in the case of a corporate body under the terms of its constitution, which obliges him or it to apply the assets in question for exclusively charitable purposes. For the jurisdiction of the court necessarily depends on the existence of a person or body who is subject to such obligation, and against whom the court can act in personam so far as necessary. Nevertheless, and this is the bit that didn't get into Lord Panic's case, it should be added, for the sake of clarity, even where these conditions are fulfilled, the particular terms of the trust or constitution in question may operate substantially or partially to oust the jurisdiction of the court. Now, that is being said in relation to the constitution of a trust, in our submission a fortiori in relation to primary legislation. So this case is another plank in my argument that the contours of the inherent jurisdiction are defined by statute, among other things, but also by the constitution of the trust itself. We can put that one away and just go back to our case at page 204. Picking it up at 28.4, we say that the position of the members of a company are obviously at one remove from its day-to-day management when compared with the directors. So if it is the case, as it is the case, that the court has never exercised a power to order directors how to exercise their discretionary power in relation to a charitable company absent a threatened breach of trust, we submit the position should be a fortiori in relation to members who are not managers of the trust property. And we then point out in 28.5 the points I've already made in relation to the analogy between the powers of the Charity Commission, which are said to be concurrent with those of the court, and therefore we would suggest are intended to be coextensive, and the powers of the Charity Commission are, like the court's power to sanction certain proposals, but not to be involved in the administration of a charity. That's section 20, subsection 2. And just for the sake of completion, the completeness, at the top of 205, the next page, my learned friend has relied consistently on section 1 of the Charities Act, which defines a charity as an institution which falls to be subject to the control of the High Court in the exercise of its jurisdiction with respect to charities. That doesn't assist you in any way in identifying what the scope of that jurisdiction is. It simply says that it has to be subject to it, whatever the jurisdiction delivers. And then in relation to paragraph 28.7, we refer to my learned friend's various authorities, most of which my learned friend Mr. Morpus has already dealt with. Lang, we've seen Chinachem, we've seen Construction Industry Training Board. The only 2 points, the only pairs of cases that I would just wish to emphasize were the 2 that my learned friend did go to, Lord Panic went to in his oral argument, was Ashton and Oldham. I don't ask you to go back to those, but both of those cases were cases involving an application to the court to approve something which the trustees wanted to do. They are not in any way authority for the proposition that the court can intervene uninvited, i.e. in the absence of the surrender of discretion by the relevant decision maker, to usurp that decision maker's discretion. Ashton and Oldham don't help at all, and although my learned friend didn't go to it in his oral argument, in his case, there is in his written case, there's a reference to the decision in Snowden. I don't ask you to go to it, but just so you have a note, Snowden is in volume 5, at tab 89, MS 2392, but exactly the same point can be made in relation to Snowden. It's an application to the court to approve something that the trustees wanted to do, not an intervention by the court usurping the judgmental discretion of the relevant decision maker. We can then go back and just try getting through the rest of what we got here. A paragraph over the page, back to our case, page 206, paragraph 29. We talk about the court's scheme-making power, and I've anticipated everything here, but just to emphasize the points in 29.1, 2, and following, it is not the case that this was an application as a matter of form for a scheme. Second, as I've already emphasized, the application could not have been made by way of a scheme because the machinery isn't broken, and what was being asked for was not putting in place a mechanism to run the trust, but to substitute the court's discretion for the decision maker's discretion. And that's essentially the point that we're then emphasizing in 29.3. 29.4, you've probably already got this point live, but repeatedly in, I think I've already made this one. This is the sort of greater and lesser argument, which I think in fairness I probably already have covered. And 29.5, you'll see what we say, and I don't need to develop that orally. I do want to spend a little bit of time just on paragraph 30, practical and policy considerations. We do say that there are at least 3 important practical and policy considerations which militate against the court having a jurisdiction to direct members of a company how to behave absent a threatened breach of trust. The first is that although obviously when trustees apply to the court when they're surrendering their discretion, they owe a duty to put relevant material in front of the court, the fact is going to be that somebody who in this case has been involved in the charity since 2002 is going to have a different fund of knowledge from what is put in front of the court in the context of this case. And as learned friend Mr. Morpus pointed out, those who were parties to the original action had all signed up to the support agreement, and Dr. Lehtimaki had extremely limited opportunity to put in evidence, but in any event, as I also say, his decision is now and that was then, and his decision will be taken in relation to the circumstances as they currently exist. Over the page, 30.2, MS 208, we say that the court should be wary of discouraging people from becoming members of companies or donors by appropriating to itself decisions which, by choosing to participate in a charity, the donors or members would expect to take themselves. We footnote there the decision in the Attorney General and Exeter. I don't think you will get anything by looking at Andrews and McGuffog because that really just follows it. But Varsani and Jasani, we would also commend to you as important recognitions by, in Varsani, the Attorney General about the importance of not discouraging donors and participation in charity by membership, among other things. The third point we make is that if the court had power to intervene in the absence of any threatened breach of trust, that would be likely to increase charity litigation, and that, in our submission, is an obvious point of common sense, and the court should deprecate any supposed evolution of the law that would be liable to increase litigation. It is a sad fact of life that people involved in charities very often feel extremely strongly exactly the opposite of other people involved in the same charity. Any opportunity that was given to dissenting, unsuccessful minority members in a charity who might think that they can persuade the court to come to a different view from the majority by invoking the court's supposed power to intervene absent a breach of trust would be a charter for dissenting aggrieved minority members in charities to take the matter to the court and say, you know better than the majority. And in our submission, that would be a retrograde step. And if that's not speculation, that really is just plain common sense. The public law analogy doesn't really take matters very much further. Malone Friend didn't really push it, but if there is any analogy to be had between public law and the situation here, as my Lord Reid put yesterday in the course of argument, the fact is in public law cases, the court rules on the lawfulness of the public decision maker's decision. By analogy, in this context, the court in charity cases, yes, it can rule on whether or not there's been a breach of trust, but it should not trespass into taking decisions, policy decisions, because that is exactly the sort of thing that ministers are meant to do. It's exactly the sort of thing trustees are meant to do.
It occurs to me it also illustrates your point that an inherent jurisdiction is not an unlimited jurisdiction.
Yes, indeed. Then finally, over the page, we touch on professional commentary, which speaks for itself, and I don't need to go back to that. And then we have the arguments that are specific to this case as to whether or not the court can order Dr. Lehtimaki what to do. And this, to some considerable extent, brings us back to the ground we've already covered in relation to the interaction between Section 217 and what the court was invited to do. What we emphasize here is that, as I say, Section 217 applies to companies generally. It hasn't just survived as a sort of accident in relation to charitable companies. It has been specifically adopted and adapted and added to in relation to charities. What we say at the top of page 210, 35.1, is it would cut across the statutory regime for the court to assume control uninvited over the outcome. And we say that it is axiomatic that the court's supervisory jurisdiction in relation to charities cannot be exercised in violation of applicable legislation. The one case we cite in relation to that is the Construction Industry Training Board, which is Authorities Volume 1 at tab 12. The relevant passage in the electronic bundle is MS, just for your note, is MS 721 C to D. I mentioned earlier, and I don't think I gave you the reference, you get the same point also from Gilmore and Coates, which is volume 4, Authorities Volume 4, tab 74, and the relevant passage is at 2176. And by analogy, we've already seen from the Liverpool case we looked at a moment ago, where the court's inherent jurisdiction can be constrained not by anything as legally powerful as primary legislation, but even just by the constitution of the charity in question. And so we do urge on you that essentially the point that we're making here, it's shortly stated, but it is important, is that what the Chancellor did was inconsistent with statute. He overrode the regime which Parliament has specifically put in place, and that cannot be done either directly by obviating the need for a Section 217 decision by saying, I am taking this decision for SIF, i.e. for the directors and the members, and it cannot be done by ordering Dr. Lehtimaki how to vote, because that is paying mere lip service to Section 217, but essentially by sleight of hand, producing a compelled result which does not allow a free vote to the members, and plainly what Parliament intended under 217 was a free vote. The points we then make in 35.2 and 3 I think I've already developed. we urge you to recognise that the consequence of my learned friend's argument is indeed that the court could override the statutorily appointed regulator, the Charity Commission. And in our submission, that just demonstrates the implausibility of the argument that's being run in front of you. The final points we make in paragraph 36 in this context are fact-specific to this case. The one point that one might add as a sort of notional paragraph 36.5 is the point that's been raised, I think, by my Lord Wilson, which is that on the facts of this case, it is also unnecessary for the court to assume the function of directing Dr. Lehtimaki how to vote, because if, in the events which have now happened, Dr. Lehtimaki behaves in a way which is harmful to the company, whatever that might involve, by either refusing to vote or demanding exorbitant information and causing everything to take forever, or by voting against it and the company directors consider that is harmful, there's the power to remove him as a member. So just on the facts of this case, there is that power to which my Lord Wilson has drawn attention. So for that reason also, it is unnecessary for the court to assume this exorbitant jurisdiction, which it has never done before. That is what we wanted to say in relation to the main issue. The other issue that's identified in the Statement of Facts and Issues is the question whether or not members owe fiduciary duties. And obviously the purpose for asking that question is that it is capable, the answer is capable of informing the answer to the second question. The court might feel that if somebody is a fiduciary, the court might be a little bit more willing to direct them how to behave than if he weren't. So that is the purpose for which it's asked, and that's why we dealt with it in our written case first. I don't have a lot of time, or indeed a lot to say that isn't already said in our written case, so I'm not going to spend long on it. Again, the starting point here is the same as the starting point in relation to the supposed power of the court to direct a member how to vote, which is that it is entirely unprecedented. We have got this far, if you date sort of modern charity law from the reign of Queen Elizabeth I, we have got through 400 odd years plus without this concept having been regarded as forming a part of the law. That, in our submission, is not the result of judicial inattention to a state of affairs which has subsisted all along. It is simply a reflection of the fact that members of charitable companies do not owe fiduciary duties. Again, yes, the court can develop the law, but it should only develop the law in relation to an obvious point of necessity, in relation to which there is an obvious answer, and in relation to which it is not obvious that there is a strong likelihood of adverse consequences. Now, we've spent a considerable amount of our time in our written case, as you may recall, identifying the risks that would be incurred if members are made into fiduciaries. You've heard something from my learned friend Mr. Morpus on the same point. It is pointed out against us by my Lord Panic that the Charity Commission in its RS7 publication didn't seem to agree, and it said that it considered that members should owe fiduciary obligations. To which we respond in saying, first, that is a publication which is now 16 years old. It is not apparent whether that remains the Charity Commission's view. It is not apparent whether the Charity Commission formed that view having considered the arguments that have been deployed, or akin arguments that have been deployed in this case. But what it does demonstrate is that this is an area, if you think simply in terms of a policy development of the law, choosing to make a decision that has never been taken before, what you are faced with is conflicting, and in our submission on our case, powerful arguments against, perhaps some arguments in favour, but it is such a policy-driven issue in respect of which different opinions may well be held, in respect of which you don't have empirical evidence in front of this court. Now, it has been said, as you remember from Coates and Gilmore, the remark that charity law develops empirically. In an area of law where there is no empirical evidence, where a development is being urged on you which has never previously been found necessary, and the court doesn't have the material to assess what the results would be of taking this step backwards, we would urge you to accept that this is an area where, above all, Parliament only should, if necessary, consider the matter through consultation, when the opinions of what are now called stakeholders will be taken, and an informed view can be reached. But for this court, absent any evidence, absent any precedent, to take a leap in this way, in our submission, would be entirely unjustified. The need for it simply hasn't arisen. Now, my Lord Briggs pointed out, well, the only issue, and indeed a similar point I think also from my Lord Wilson, the only relevant duty that has been identified here in the courts below is a duty to exercise the power under section 217, bona fide in the best interests of the company as a whole. It is a matter of taste whether that should be regarded as a fiduciary obligation at all. It can exist as an obligation without anybody suggesting that it is a fiduciary obligation.
But it's one breach of which will be as much under the court's jurisdiction as a fiduciary obligation.
The consequences would be different. I mean, to say that somebody owes a fiduciary duty implies that they face personal liability for acting in breach.
Leave that aside.
If there is a duty on members collectively to exercise their power in the best interest, what they believe to be the best interests of the company, and that is broken, that the result may be that the resolution is void, not that they are personally liable to anybody. So it may well matter in terms of remedy whether you characterize it as a fiduciary duty. But can I just offer this word of warning? We do urge you to remain loyal to the limits of what the statement of facts and issues asks you to decide. The parties do spend a certain amount of time haggling over and coming to an agreement as to what needs to be decided. The question that you're asked in the statement of facts and issue, well, the two questions that you're asked, if you want them in front of you, they're on page 77, MS 77, are paragraph 22, A, whether the court had power to direct Dr. Lehtimaki to vote to approve the grant in the circumstances of this case, and B, to the extent necessary, whether the court was right to hold that a member of a charitable company is a fiduciary and therefore owes fiduciary duties. On the face of that, you are not asked to opine on the question, if a member is not a fiduciary, what duties might he owe? And the reason I mention that is this, that the Court of Appeal, in paragraph 30 of its judgment, mentions a tension between, on the one hand, a bit of a throwaway line in Allen and Goldreef's, which says that members of a company, when considering whether to alter the Articles of Association, owe a duty like any other possessor of a power which is capable of binding a minority, to exercise that power in a way which they consider to be in the best interests of the company. That is what Allen and Goldreef said. It's not what the case was about, but it is a throwaway line that's in there. What the Court of Appeal in this case say is that they mention that, but they also mention the long-held position in the case law that the members of a company are entitled a priori to exercise their voting rights selfishly. Now, there is a tension between the Allen and Goldreef's suggestion that the donee of a power owes a duty to exercise that power in the way which he believes is in the best interests of the company as a whole. And on the other hand, the long run of case law saying that members can vote selfishly. Lord
Mr.
Justice.
Crowe, at the moment, I don't fully understand why you say that we are not asked to consider or decide whether, if he's not a fiduciary, what obligations does he owe? Because I think that is part and parcel of the suggested answer to the first question.
If you find it necessary to answer it in order to answer the first question, I entirely take your Lordship's point. But in my submission, it doesn't arise of necessity. And it doesn't arise simply because on the facts of this case, no member has voted yet. If, in due course, the Charity Commission gives its consent, and if, therefore, Dr. Lehtimaki gets a vote, and if, in the event, he votes against, and if Ms. Cooper then wishes to suggest that he has thereby acted in breach of some duty, at that point, the issue would arise, assuming he's not a fiduciary, and the argument could then be had. But in our submission, that is not now. And the last thought I would just leave with you is that there are three cases that the Court of Appeal look at in paragraphs 39, 40, and 41 of their judgment, which they rely on by analogy to support the conclusion that members do owe fiduciary duties. And the first one is called Skeet. I can give you the reference to that in a moment, which is Authority Volume 5, tab 88, MS 2385. What is striking about Skeet is that it was a case in which a marriage settlement had been created, trustees were appointed, and a power was given to the husband and wife to appoint replacement trustees. That power was then exercised when the original trustees retired to appoint the husband as a trustee, and it was said, well, this is a fiduciary power. The fiduciary, the person owing the fiduciary obligations, can't exercise it in his own interest. So the appointment by the husband and wife of the husband was a breach of trust. Now, if it is right that members of a company, a charitable company, owe fiduciary obligations in relation to the exercise of their powers, it would mean that neither Miss Cooper nor Sir Christopher could ever have voted for themselves to become directors of the company, and that would be an astonishing outcome. So the implications of imposing fiduciary obligations are, in our submission, significantly dangerous, wholly unforeseen, and nobody so far has proceeded on the basis that this is the law. We do urge you not to go down that road. With that, I don't think I have anything more that I need to say in support, and I have run out of time. So can I just finish by mentioning the very final point that my Lord Panic mentions in his case, which he acknowledges is irrelevant, which is the suggestion that my client is acting in breach of contract. In our submission, it plainly isn't an issue that you need to decide. My client is here to assist the court on points of law. He is, as you will have seen from the papers, said to be the UK's most generous charitable donor and has been knighted for his services to charity. So to suggest that he is acting in breach of contract by assisting the court in reaching a correct view as to the process that needs to be followed in order for this grant to be paid, in our submission, is in itself unarguable, but I merely say that not for you to decide it, but for you not to be left with any sense that there is anything in the imputation that has been cast against my client. And the final point is that if and insofar as anything my learned friend Lord Panic has said implies that the Chancellor's ruling was made in order to prevent further litigation, in our submission, any implied threat in that remark to sue my client should be entirely disregarded, because that is not a point that is going to assist you in deciding on the points of law that are under appeal. If Ms. Cooper chooses to sue my client for me having stood up and said what I said in front of this court and the courts below, then that is a matter entirely outside the determination of the issues under appeal. Unless there's anything I can assist you with, those were our submissions.
Thank you very much, Mr. Crowe. Yes, Mr. Henderson.
Lord, Lady, I intend to start with outlining our approach rather more quickly than it's set out in the case. I then will move on to deal with the complications introduced by the use of the word fiduciary, and indeed rather echoing something which Mr. Crowe has just said, the lack of need to use the word fiduciary in the present case. I will look, if I have time, at the statutory constraints on members' powers, and then pick up a miscellany of points which have arisen as the case has developed. In fact, I'm going to immediately depart from my proposed timetable and start with one of the miscellaneous points, because it is fundamental to everything which your lordships and lady have got to decide. And that's the question which has been, I think, raised, or the expression has been used, the best interests of SIF. That is not the duty either of the directors or of the members. The duties of the directors and the duties of the members, insofar as they might reflect the duties of directors, are as set out in section 172, subsection 1 and subsection 2 of the Companies Act 2006. The reference is volume 4 of the Authorities Bundle, tab 54, MS 1831. And that, or those subsections, alter the general duties of directors of ordinary commercial companies in the case where the objects of the company are to promote a set of purposes rather than anything else. And charitable companies do promote a set of purposes, and the consequence is that the duty is that the persons concerned must do what they consider in good faith would be most likely to achieve the charitable objects, which is subtly different from the best interests of the charity. It particularly resonates where one looks at this question of what the $40 million which were being paid, or the $360 million which are being paid from Charity A to Charity B, were going to be used for. Because Charity B, Ms. Cooper's charity, is going to use the funds under the terms of the grant agreement for substantially the same purposes as SIF would use them if it retained the funds. Therefore, when the money is transferred across from one charity to another and is used by the second charity, that will in itself be furthering and achieving the charitable object of SIF. So, looked at from the perspective of the directors of SIF, they weren't losing 360 million, or wouldn't be losing 360 million pounds for the purposes of carrying out the charitable objects, because those charitable objects would be carried out by the recipient charity.
That was a point made to the Chancellor, was it?
It was, lady, yes. And as I think somebody said earlier, the Chancellor didn't like the list of issues which various council had prepared for him and produced his own, which reformulated the test. And perhaps, while I'm on the subject, because it is an important point and needs to be dealt with, the question of the surrender of discretion, who surrendered what and what was the consequences. As I think Lord Briggs commented yesterday morning, at most the surrender of discretion in this case would be analogous to any of the categories in Public Trustee and Cooper, because one's concerned with a company, not with a trust, and public trustee was concerned with a trust. The purpose of the surrender of the discretion and the effect of it, in my submission, is that the court steps into the shoes of the relevant decision-making body and makes the decision on behalf of that decision-making body. So, in the present case, on behalf of the directors. And one gets that from what's laid out in Public Trustee and Cooper, the passage which has already been referred to, and there is one additional sentence in Mr. Justice Hart's judgment, which I won't take you to, which in my submission confirms that. That's at page 925D of the report, and that's MS 2295. The Part 8 claim form, which was issued by the company, seeks in its paragraph 1 the relief which the company was obliged to seek under the terms of the April 2015 agreements. It seeks the approval of the court to the making of the grant. Two-type application. The trustees have decided and want the blessing of the court. They want the approval of the court to what they've decided. But that's not how this worked as a matter of mechanics, because the April 2015 agreement was in part unconditional and in part conditional. Many of the unconditional parts had already been affected by the time the matter came on for hearing before the Chancellor. The conditional part was as to the payment of the grant, should the grant be paid or not. The hearing before the Chancellor was some 2 years after the April 2015 agreements had been entered into. And there had been a change of circumstances in the intervening period, in particular the raising of the Section 217 Companies Act point, and there was a suggestion at one stage that there would be various adverse tax consequences from the payment of the grant. So the trustees, directors, in deciding to enter into the April 2015 agreement, clearly hadn't taken those considerations into account. All they decided in April 2015 was it was a good idea, it was in the interests of the charity, to use that phrase, or was most likely to achieve the charitable objects, for them to enter into the mixed conditional and unconditional agreement. So the court, stepping into the shoes of the directors, as at the summer of 2017, the Chancellor, had to decide for himself whether, in the circumstances they then existed, having regard to Section 217 point and the tax consequences, amongst other things, whether it was most likely to achieve the charitable objects of CIF for the grant to be paid. There's no suggestion in the April 2015 agreements that the directors should have a second bite at the cherry as a result of the change in circumstances. That would clearly not have been the sort of thing which was contemplated, because that would leave Miss Cooper and her new charity entirely at the mercy of the directors. The directors were obliged, if the court approved the grant, to pay it. The court had to decide, looking at it as if it were directors of the company, as to whether the grant should be paid or not. And those were my two preliminary miscellaneous points, and this may be a convenient moment.
Yes, certainly. 2 o'clock.